I want to bring in my guest for this hour, criminal defense attorney Lara Yeretsian. Lara, great to see you again. Thanks for being on the show.
Good to see you too.
All right, so let's start off by talking about these two victims. You have Robert Goodwin, you have Lauren Canarak. I want to get your take on how they did on the stand. For me, I think they both were somewhat credible, but I think they came off as being people who were just as involved in this mess as the defendant.
Right. They don't come across as very sympathetic victims. That's pretty clear. And it's not just what they've said. For example, Canarak actually admitting, some of the issues that they were having and how she wanted to destroy Barisone and his girlfriend, and Goodwin kind of, admitting, even if he doesn't admit it, it was pretty clear that there were some threats going on here from their side. So there's also the way they were talking and behaving on the stand. Canarak couldn't even keep good eye contact. A lot of times she was looking down or closing her eyes. And to me, that's a sure tale of somebody who's thinking and possibly lying or is very uncomfortable. And the jury is going to pick up on that. Yeah. And Goodwin had an attitude, and that attitude is not going to help much for him.
Yes, and I think you sort of nailed both of my issues with them. I thought her physical movements, that's Lauren Canarak, definitely belied that she was maybe not being as honest as she could have been. She was telling a story. And then for Goodwin, just his whole posture, just look at him there and his attitude, he just came off as someone that you would think could be doing all the things that the defense says he was doing. And so my question for you is, now this whole thing for me just became a big mess after their testimony. I didn't think the cross-examination was as effective as it could have been. I thought he didn't control the witnesses very well, gave them a lot of opportunity for open-ended answers, which can be problematic. But I don't think it hurt him that much. But at the end of the day, this whole thing, again, as I said, seems like a mess. Where do you think that leaves this case as far as the defendant and being found guilty?
Well, for his sake, I would say, even if it gets him a mistrial where the jury can't decide, they don't have a unanimous vote, that would be great. Or an acquittal. I would hope that he gets an acquittal, just based on what I've seen. Again, jurors can see through witnesses, and they can see when a witness is lying. And I would hope that they can see that, because that's the way I felt towards these two witnesses, putting aside how the defense attorney did, whether he could have done better or not. I'm hoping they could see that these two are not being very honest. And if there's a bully here, it's possible that the two bullies are the two so-called victims.
Yeah, exactly. And the other thing about this case, and I've been checking in with all of our guests regarding this dual defense, the self-defense and the insanity defense. They're required in New Jersey to try those two things together. Up until about 2013, they were bifurcated. You would actually try the insanity first, then the self-defense if you weren't successful on the insanity. But then the New Jersey Supreme Court said there's no right to bifurcated trials. You'll do them together. Your sense on that and that approach by the defense?
I guess, now that they can't bifurcate the two, so they have to present both, why not? If they can, all they have to do is create, number one, reasonable doubt, right? If they can create that reasonable doubt, he's going to get acquitted. And if they've got two different ways of doing it, they've got to do both. They can't, look at him. You look at him, you can see that he's a mess. And a jury maybe might buy the insanity defense. That's a tough one to prove, but at least it'll give the jury the possibility of finding a reasonable doubt, or maybe even nullifying. You never know. So I don't think it's going to hurt.
And as you said,
I think it helps the defense.
Yeah, and I agree with you. And when you look at him, that was going to be my next question. What do you make of the way he looks? He cries at various times during court. He absolutely looks crazy. Again, there are certain people online, again, who believe he might be playing it up. It's all part of their insanity defense. But if it is, I'll tell you what, Lara, he's doing a very, very good job at it. What do you make of how he looks and whether that might be a tactic, or do you think he's just lost it?
He looks the part, and the jury's going to have to decide. The jury's watching him all day long, and they're going to watch him throughout the trial. And if it's just not him looking the part, I'm hoping that they're going to be able to get a good read on him and see how he is throughout the day. It's hard to put up an act all day long, all week long, or for several weeks. The jury's going to be able to see through it. But And there's got to be more than just the way he looks. I'm sure the defense is going to have to present more than that, and maybe the jury's going to have enough. But again, the insanity part is not an easy one to prove. I'm hoping that they can prove or show some kind of, they don't have to prove it, but they can, there's some reasonable doubt at least created by everything that the defense is presenting.
Yeah, and the defense promised in opening statements they're going to bring in a psychiatrist and a psychologist to help the jury understand that dichotomy between the self-defense and the insanity defense. It's a criminal offense to use any device to record or share communications without the consent of at least one person taking part in the communication. Again, all that means is that one party can decide to record the other party. They don't need the other party's consent. Lara, correct me if I'm wrong, but in California, you need both parties' consent. And I'll follow that up with a question. Why do you think states would allow for recording with only one party consent?
As you said, in California, it's two-party state unless one of them is committing a crime, then you don't have to tell them that you're recording them. That is allowed. That's the exception. I'm not, since I'm in California and I've always noted as a two-party state, I would think that they're just giving people the ability to record people without the fear. Sometimes you don't really know when the person is going to commit the crime, and it gives you the opportunity to have the recordings and finally get the one where the person is, let's say, extorting you or threatening you. It just helps them get the evidence. I can't think of any other reason why they're doing it, honestly.
Yeah, I agree. I guess that's some sort of deterrent in some way. I really don't know. It makes much more sense to have it be a two-party consent state for privacy reasons. But, right? Doesn't it? I mean, that's how I see it. All right, Lara, stand by. We're going to take a break. All right, still with me, criminal defense attorney Lara Yeretsian. Lara, I want to get your critique of that cross-examination. It was a consistent issue for me, just the lack of control of the witnesses. I mean, they were continually able to basically opine and say different things that would help their story. I could see what the defense attorney was trying to do, trying to create this idea that maybe they corroborated and created a story between the two of them. But again, just too much freelancing there allowed by this witness.
Agreed. I mean, usually when we're cross-examining a witness, we've got the story in our mind, and the question is, you did this, right? You did that, right? This is what happened, correct? We're not giving them the opportunity to give us their own version. Okay, there are some times that we do, but a lot of times we're the narrators, and it's our story that he or she is admitting to or not admitting to. And each attorney, they've got their own style, and I'm not here to criticize what he's doing, and each has their own style. But unfortunately, the defense attorney could not get him to admit something that's very common sense. Most likely they did speak about this, and he was just being a witness that was not cooperative, basically. And maybe the jury could see that, and that could save the day for the defense.
Yeah, I think that kind of came across, the idea that it's obvious the two of them were in the same place for a period of time. They would have talked about this so quote-unquote life-changing event. The other thing was, and I agree with you, this might have been part of the defense attorney's tactic. He did it with Lara Yeretsian as well. By letting them talk, he was giving the jury a sense of who they are and the type of people they are. And I think it was particularly effective if that was what he was doing with this witness. Because as he was going on and during the course of his cross-examination, I was like, gosh, I would hate to be in a situation where I would have to try to work something out with this guy. Just his body language, his attitude, all of it just feels wrong.
Agreed. I mean, you could see the attitude and the way he was leaning back, and it was almost like he was ready to fight. Of course, not physically, but and that attitude, the rolling of the eyes. He doesn't come across as sympathetic. He comes across as someone who could have been the bully.
Absolutely, and he said he stood on the porch while the two of them talked. I have trouble believing that. He doesn't seem like the kind of guy that's just going to stand by on a porch while his girl goes out and talks to this guy. So anyway.
Agreed.
Right? He just doesn't seem like that kind of guy.
Yeah, I can't believe that. I can't buy that.
Yeah, and he could obviously handle himself in a fight. He put the guy in a hole, broke his arm. Anyway, Lara, I want you to stand by. Lara Yeretsian. Lara, I want to talk about bail a little bit, because one of the things that kept coming up during the Mosley trial was, why was this guy out on bail? Now, he was a violent felon, out on bail. And I think at that time, one of the issues was the prisons were crowded, and that's an issue everywhere. I'd love to get your thoughts on bail, because quite frankly, there is a right to bail. There is a the Constitution speaks to it, that your bail can't be excessive. I want to get your thoughts on bail.
I think bail should stay as part of the criminal justice system. And there was a movement at some point, even in California, to get rid of it outright and to replace it with another system that has to do with points and different things, factors that are considered, and to decide whether someone should be out or in. No, there were no other options, and that, that it didn't work out. We do have certain counties, for example, in Los Angeles, the district attorney, in effect, has decided to follow that in most cases. For example, misdemeanors, most misdemeanors don't have bail unless there's certain exceptions, like domestic violence cases where there is bail, and it's a pretty high bail. It's a substantial bail. It could be $50,000. And so the felony cases that involve violence also involve bail. So I think bail should stay as personally, I think bail should stay as an integral part of our system, because it gives people the opportunity to get out if necessary, especially when technically we've got this presumption of innocence, and people should be allowed to get out. And there are some circumstances where judges can also add conditions. For example, they can say that you need to stay at home on house arrest, you need to do counseling, you need to do drug program, you need to do DUI classes, whatever it is. There's ways of protecting the public. So I think it should stay, with sometimes the judges being able to add possibly some conditions, and in some cases they shouldn't have bail, especially for the misdemeanors.
All right, but I want to bring up some of the issues that are raised by bail. Now, pretrial incarceration, which is, if you can't pay the bail, makes bail really a wealth-based system. And that's one of the complaints, the idea that those who don't have money end up in jail. Those who have money are able to get out of jail. So there's that issue. The other issue is, and I was surprised to find this, is that pretrial incarceration is really the biggest driver of convictions and why the jails are so full with poor people. Because at the end of the day, if you're not getting out, you're much more likely to plea. And as we know, wrongful convictions, wrongful pleas, all these things happen all the time. And there is a presumption of innocence. So how would you address that issue? And that's one of the big issues, that, of course, wealth is at the center of it. It's not dealt with equally between the poor and the rich. And also the idea that it drives people to take pleas and end up doing jail time for things that they didn't necessarily do or haven't been convicted of in a court of law.
I agree with both points. I think someone who's poor and you set a bail that's excessive, they're never going to be able to get out. And the wealthy person can always come out. They'll find the means, resources to come out. And for that reason, courts, for example, in California, are supposed to take into consideration the ability of that person to make bail. And if they can't make it, then what's the point of setting it? So things have got, there is this movement that's very pro people who are unable to meet the high bail. And that's why what I was arguing, what I've been advocating for is this combination, the system that keeps bail for the really violent crimes where you do want to have, pretrial incarceration in some cases, or have such a high bail that the person will not leave town, will not flee. And you have other factors also, other terms that keep the public safe. But at the same time, you get rid of bail for the misdemeanors and for some of the crimes that are just nonviolent. You don't need bail. The one thing I've learned throughout the years is that someone who's going to commit a crime will commit it, whether you set a high bail or a low bail. They're just going to do it. The only thing that does is keeps people incarcerated. And like you said, it almost forces them to take a plea deal because they want to be done. Sometimes, they're stuck in there because they're still waiting for trial, and that could take months, sometimes up to a year. And then the offer is better. The offer is, let's say, 15 days, 20 days, or no time period. And the person says, you know what, might as well. I can't afford to get out. Why don't I just plead? So I think that's not a good thing, and you don't want to have that. And for that reason, I think the middle ground for this problem is have a dual system where you've got bail, but also have other ways that people can come out, alternative methods.